from that introduction. First of all, I'm going to try to share my screen and try to show a PowerPoint. And let's see if we can get this to go from the beginning.
Looks good to me, Mark.
Yeah, I'm having trouble here getting it.
Oh.
There's like something blocking my screen here to do the old-fashioned slideshow. Oh, here we go. Okay, hold on. Here we go. Without further ado. Yes, it works. Progress here. By the way, this is very exciting because I guess this is the last time we're going to do this before we actually are meeting in person. It's also a very important day. This is the last day I officially can wear a seersucker suit before the fashion police come after me. We're here to discuss legislation that was passed by the recently, well, not too much, that's not so recent anymore, the 2022 session of the General Assembly. It was what we call a somewhat shorter session because it's an election year. It ended in May. It wasn't as transformative, I would say, as the 2021 session or especially the 2019 session. But there was legislation that of some import. So let me just start the games. Here we go. And actually, this was the slide that would have just told you all the things I just said. Okay, bills that passed. Those are the ones we care most about. If we have time, we'll talk about bills that didn't pass because again, bills don't pass this time may, come again and reemerge like those Friday night horror flicks when the creature comes back from the dead. This one, I'm going to start off with. This is called officially an act protecting employee freedom of speech and conscience. It's also known primarily as called the captive audience bills, and it generally prohibits employers from requiring employees to attend or listen to, importantly, or view communications. I assume that's because of we're now not all we can be doing things virtually that are sponsored by the employer, which the primary purpose, there's the key, primary purpose is which to communicate the employer's opinion concerning religious or political matters. Usually at this point, someone will always raise the issue, well, gee, Mark, is this preempted by the NLRA? That's something I will let other people decide if it is, because there's been some people raising legal challenges on this. But I'll just go through the bill that exists. Now, there are exceptions in here. For example, there are certain, obviously you can communicate with your employees information that you're required by law to communicate so employees can do their job. There's specifically an exception for higher education. I'm not sure if there's any higher education folks here, communicating with, materials that are part of the coursework or a symposium. There's a casual conversation exception, which means that if there's a conversation, I'll call it a water cooler conversation between an employee and a higher up, it's okay as long as it's not required. And also you can still have a meeting where you provide your opinions, if you're an employer, to your managerial and supervisory employees. There's a broad exception that this law doesn't apply to religious corporations and entities and associations or that are exempt from the requirements of Title VII or CFIPA with respect to speech or religious matters for employees who perform work connected with such entities' activities. Basically, you're a religious entity and you're performing work connected with the activities there, you can communicate on the employer's religious matters. Now, it was a captive audience bill, but that was not it alone. There were some changes actually to the state free speech, what is known as CGS, Connecticut General Statute 31-51Q. Some changes to that law by which were kind of, I don't want to say snuck in, but they were not viewed with as much interest, but people discovered, hey, wait, it's in the law. It will it limits the damages available to it to just gross lost wages and compensation. And it would eliminate any right to punitive damages. Now you could still get attorney's fees, but the right to punitive damage is expressly gone. So on one hand, that's would be viewed to be pro-employer. But on the other hand, it extends the grasp of the law, the reach of the law to prohibit employers from even threatening the subject and employee to discipline or discharge. Previously, it was just discipline or discharge, a threat to do so. Now is covered by the prohibitions of 31-51Q. Wage theft. This is, again, mainly for the those involved in prevailing wage issues, state, contractors. This may be of interest to some. This empowers the increase in ability to issue increased fines to contractors who violate the state prevailing wage laws, to $5,000, per violation. And I call this not necessarily the naughty or nice list, just the naughty list. Those in the previous 3 years who violate these laws or entered into a settlement agreement to resolve the claims. There's this list that will contain a list of the violations and the amount of wages and benefits making up the violation, the amount of penalties, and it'll be a rolling 3 years. It'll be viewed to make sure it's up to date, and also here's another thing: refer for debarment any contractor that committed a violation during the rolling 3-year period. Now, again, the key word is may refer for a debarment. Now, you shall, again, shall means shall, debarment contractors, and that also applies, obviously, to subcontractors that entered into a settlement agreement where the total of all settlements within the period exceeded $50,000 in back wages or fringe benefits or civil penalties. Now, if you're facing this, if you're a contractor or subcontractor, you have a right to request a hearing before the commissioner to contest the being placed on this debarment list. Now, the next bill concerns that there was a task force to study cancer relief benefits for firefighters, and right now there is a firefighter's cancer relief account, which is separate from workers' compensation. It's a separate benefit. And what this bill does is it requires, starting in January 24, it requires every town to make a contribution of $10 per firefighter within the town to the firefighter's cancer relief account. Now, it's important to know that it's limited to certain eligible firefighters in terms of making this up, who accounts. It would include, I think if I look at the law, those who have, I think, based upon have 5 years, who have worked the last 5 years in a position, whether it's as a firefighter or as a fire marshal, and also have submitted to a physical examination within that did not reveal evidence of cancer or propensity for cancer, and have not smoked cigarettes for the last 15 years. Those are kind of like what the eligibility is to get the benefit. That is what counts in terms of those who are eligible. It'll be $10 per eligible person the town must contribute. Now, there's some other things here. I don't claim to be an expert on firefighting. I do heart and hypertension work for fire departments, and I do some work, employment work. But there's going to be a standards for toxic substances on firefighter turnout gear that'll be submitted. How to, in terms of removal. There was talk about having to wash this stuff out. This is stuff that will be given by the task force in July 1st of 2023. And it also requires the Workers' Comp Commission to maintain a record of all compensation claims made due to a cancer diagnosis. Now, this is workers' compensation claims, not the Cancer Firefighters Relief Fund account. And last but not least, it requires the controller to conduct a feasibility study on providing pension benefit for firefighters where you did not reach that level because you had a qualifying cancer diagnosis. What's important was not what was not in this law. There were attempts to change the workers' comp statute to create a rebuttable presumption for certain cancer diagnosis, kind of like what exists for heart and hypertension. This act doesn't do that. In fact, it expressly states that an award under the firefighters cancer relief account does not create a presumption for workers' comp benefit. This is a retirement bill for seniors and reemployment. And CMERS, for those who aren't acronym proficient, is the Connecticut Municipal Employees Retirement System, which many municipalities participate. You can participate, basically would allow for reemployment for those during the period of reemployment. In other words, if you get reemployed and you don't receive benefits during that period of reemployment, you're okay to be reemployed. So basically you can put a pause on your receipt of benefits after you retire, return to the workplace, just not collect the benefits. Now there's an exception in here in the law that you're allowed, I don't want to use the phrase double dip, but you're allowing certain people, retired firefighters and retired municipal police officers, to continue to receive retirement benefits, but they won't acquire further credit to the system if the personnel are being employed by a board of education in a public safety capacity after retirement. Give you the little shortcut. That means an SRO, school resource officer. That means you can be reemployed as a school resource officer, receive your compensation as a school resource officer, and still collect under the retirement system, although you won't earn any further credit in the system. There was a bill passed last year, 21, that gave to employees 2 hours of unpaid time off on the date of a regular state election and special elections, basically the elections that occur in even number years, so they can vote upon request. And also, these are basically for state offices and congressional offices. This bill expands that to include now special elections for probate court judges. Now, this bill expires June 30th of 2024. That means it applies to elections in 2022 for the state elections, special elections, and it will apply for, the probate court elections. We'll see if this gets renewed. This was an interesting bill that basically says that after it took effect upon passage, but it really takes effect October 1st, i.e. in 15 days, that law enforcement units can adopt and amend policies that, basically to permit officers to wear religious head coverings consistent with their officers' religious beliefs while the officer is on duty, except where the use of tight-fitting protective headgear is required for such law enforcement units. So this would allow, obviously you can see what it might allow people to do now for law enforcement officers. By the way, I apologize for those who do not care about police officers and police departments, because the next two slides continue that theme. There's a prohibition against discharge or discipline or discrimination against police officers for those seeking mental health services, to include services provided as a result of a mandatory behavioral health assessment. So you can't discriminate against someone who's required to receive a behavioral health assessment. Now, there's also supposed to be developed by POST, which is the Police Officer Standards and Training Council, a training curriculum for police officers about interacting with persons with disabilities or those who are deaf, hard of hearing, or deaf or blind. This is important because I think we've seen videos of some tragic situations where police officers interacted with, for example, people with autism and how they mishandled the circumstance. This is going to add to that curriculum. There's also going to be a task force to study the mental health needs of law enforcement officers on the other side. I will also, it's not in here, but there's going to be a bill to study, a task force to study the fact that whether calls to 911 should go to 211, because that's part of the broader theme of whether law enforcement is being used too much. I won't go into too much detail on this because it may be trying the patience of those who don't deal with police departments. This bill will require minimum standards and practices for law enforcement units that will have to be in place and will have to be met to ensure certification. You can read the slide, but basically that at a certain point in time, you'll have to meet certain standards in order to maintain your certification as a law enforcement department. Okay, I put this in because it does have effect, establishing a new June state holiday as of June 19th, which is Juneteenth Independence Day, which for those who don't know, that's the day when I think the proclamation of emancipation was delivered. I think it was in Texas for the last outpost. It was June 19th of 1865, where slavery was still in place. This is now a state holiday. This may have employment implications, suffice it to say, for collective bargaining purposes, for those who provide holidays off to their employees. I thought it was worth at least mentioning. Now, we've talked about in the past about the second chance society, the idea of not having people's prior convictions be held against them. And this deals with those now practitioners who have occupational licensing, that this basically the ability to revoke or suspend or deny someone their license for the commission of a felony should only apply to those who are, quote unquote, reasonably related to the holder's ability to safely or competently perform their work. Reasonably and competently, whenever you see those kind of words, you always wonder about, those are kind of words that are open to interpretation. Now, this is an interesting grab bag, a very diverse group, if possible, of those who are covered by this. It goes from architects and eyelash and nail technicians. There's the list of people that are covered by this law. And it also extends the prohibition against the Department of Public Health summarily taking action with respect to practitioners for convictions or convictions for a felony to cover licenses for embalmers and funeral directors. Else, for purposes of full disclosure, I do have a relative who does own a funeral home. This is actually a fairly big bill. It's called, it has a really long title. And I just dealt with the part of it that's relevant to us, the provision of domestic violence training and protections of victims of domestic violence. First of all, right now there was a 3-person threshold for CFEPA, the Connecticut Fair Employment Practices Act. On October 1st, it goes from 3 to 1 or more. So if you're more than 0, I guess, but 1 or more, you're covered by the Connecticut Fair Employment Practices Act. And also includes employees now will include any elected or appointed official of a body. So that's clear that members of bodies now can bring complaints against the municipality if a member of a board thinks they're being harassed. It also adds as a protected class status as a domestic violence victim as a protected class under CFEPA. This is important because there's been a long debate whether the gender discrimination statute protected victims of domestic violence. And there was some dispute whether they could claim it was under a disparate impact theory that females might be more adversely affected. This answers the question as in, yes, you're covered, a status of domestic violence victim. It provides now that's under CFEPA that you cannot, it requires employers to provide a reasonable accommodations, including a reasonable leave of absence to an employee for the purpose of seeking attention for injuries caused by or services related to domestic violence, unless the absence would cause an undue hardship. You see this now, these are concepts we've dealt with for disability claims, disability discrimination claims, but then it's now being imported in for domestic violence victims. Now, employers can seek documentation. To be fair, if someone requests a leave of absence, I think it's fair, and the law assumes it's fair for an employer to seek documentation with respect for the need to have a leave of absence. The employers now must maintain the confidentiality of these information regarding one's status as a domestic violence victim. Putting on my FOIA hat, for public employers, I would assume that these might be exempt from disclosure. And I think the Personnel Files Act would protect people, but you must do the best to maintain the confidentiality of that information if you receive information about someone being a domestic violence victim. This bill also authorizes, will now authorize CHRO to require employers with 3 or more employees, so they still use the 3 or more employee standard, to post information concerning domestic violence and resources available to the victims of domestic violence. And my understanding that this is a poster that'll be developed in conjunction with the Connecticut Coalition Against Domestic Violence. Now, this will also require state agencies to provide training now related to domestic violence and the resources available to all employees by July 1st of next year, and to those within 6 months of their assumption of the position. This is kind of like the training that now goes on for sexual harassment. The law sets forth the content, and again, the training will be developed in conjunction with CHRO and with Connecticut Coalition Against Domestic Violence, and be made available at no cost to each agency. I assume it may be the interactive online training, similar to they developed online training for sexual harassment. This is a special act. There was an act last year about Public Act 21.5, which is mentioned in the slide, about a bill about the experience rate increases. There was a bill to remove COVID-related layoffs from the experience account. But this is to study the effects of businesses that had their experience rate increase despite last year's passage, and to submit a report to the legislature's Labor and Public Employees Committee for next year. It would basically study who had it, how many people were impacted, and the cost of folks because of that. This is my favorite laws. These are the technical and other changes to the Labor Department statutes. Obviously, it makes what are called technical changes, and it eliminates obsolete provisions. I would say what is of interest for most people is having to post the unemployment, making the unemployment compensation laws be available on the Connecticut Department of Labor website. I thought they were already posted anyways, but now it's required. I can't go into detail. There were some changes last year on the unemployment tax experience rate. This revises some of them. I think it extends it to changes from 2024 to 2027. I can go into more detail if people have questions. And last but not least, I deal with questions about meal period mandates, and there's provisions in the law that an employer can get an exception to the meal period mandate for certain employees. Right now, the law requires the Department of Labor to develop regulations to establish procedures and requirements for granting this. This eliminates the requirement that Commissioner of Labor adopt such regulations because Commissioner of Labor has not apparently ever developed it, and the Commissioner will not be required to develop it in the future. Another one of those technical law changes, there's several places in the law where, where there were, in terms of notice that was provided, you'd provide to the quote unquote administrative law judge. We used to lovingly call commissioners are now known as administrative law judges. It'll now go to the chairperson of the Workers' Comp Commission as opposed to administrative law judge on certain notices. Throughout the law, it replaces the term chairman with the much more, I would say, correct and apt one of chairperson, because that's not as discriminatory, frankly. And it makes various other conforming and technical changes to the law. Implementer, everyone's favorite thing every year. It's those bills that are passed the day before the legislative session. And this year it only had 739 pages, whippy. And I think the summary that was prepared by the Office of Legislative Analysis itself was like 230 pages. You would hope the legislatures would at least read that. Okay, enough of my passive aggressive comments. In that bill, there were several employment-related provisions. So let me start here. And this may have some import, is the Connecticut Retirement Security Authority, which administers that retirement plan that exists for the employers that don't offer one. It makes directly the state of Connecticut's Office of Controller the successor for administering the retirement program. There already was a keen role for the state controller's office, to be honest, in the Retirement Security Authority. This kind of makes it official. And it makes the members of the board of directors, the current ones, into a quote unquote advisory board. And now the program has been changed. It will be called the Connecticut Retirement Security Program, as opposed to the Connecticut Retirement Security Exchange. I guess program sounds more entrepreneurial and I guess. I won't spend much time on this. This is the slide that basically talks about all your lovely non-unionized state employees. I assume there's no judges on the line, but you're getting judges are getting a salary increase of 5%. And anyone who might be on the line, who may judge a case I have, you're worth every penny of it. And also for non-union employees, it provides that these benefits, the raises that were in the CBAC agreement that occurred earlier this year, basically there was a 2.5% increase, along with annual increments, as spelled out here. And there was a lump sum payment. These are now to be paid to the non-union state employees. So they will get non-union state employees will inherit the benefits that the unionized employees negotiated through the CBAC, State Employees Bargaining Agent Coalition contract of last year. This is for the state partnership plan for the health insurance coverage to continue until at least the end of the calendar year, after when this is a change, either the person turns 26 or, this is the new language, obtained coverage through their own employment. So that could arguably cut off the age 26 provision. Teacher retirement system, for purpose of full disclosure, I work with numerous school districts, and there may be people on this line who care about it, but I'm one of them. And since I'm giving the discussion, my opinion controls. This talk, basically business administrators are now, this has always been somewhat controversial. Actually, I didn't think it was controversial that school business managers and finance directors were not eligible for the teacher retirement system. This is very clear you don't. It also gives, for those who are eligible, who were employees of the State Education Resource Center, is for those hired before July 1st of 2022. It includes it now, the Connecticut Technical and Career system, which is the old state high school system. It's been spun off as an independent agency from it's clear now they're covered by the teacher retirement system. So all the vocational teachers are covered by it. And this also increases the subsidy. There's a $220 a month subsidy given by the teacher retirement system for eligible retirees who purchase health insurance coverage from the last employing Board of Education. This increases it from $220 to $440. There's more. Similar to, the FMLA has provisions about interfering restraining with the exercise of rights or discharging someone. Basically, discrimination interference provisions in both the state FMLA. They also exist in the federal FMLA. This extends it as a violation for employers with respect to the paid family medical leave law for people to discriminate against someone for someone trying to exercise their rights under the paid family medical leave program. And also this law, another thing, reduces the unemployment tax rate that new employers must pay for 22-23 by 0.2%. This is the premium pay program that people must apply by October 2022 that is administered by the state. Out-of-state funds for private sector employees to apply for this for an payment of $2,000 to $1,000 for those who were on, I think it's phases A, 1A or 1B of the vaccination program. To be honest, I used to know those employees by heart back in 2021 when we were worried about who had to receive a vaccine. I can't tell you, but these are usually first responder type employees. I'll just say the program is with available appropriations, and my understanding that there's not nearly enough money to pay for all the claims being made. But what is important, employers cannot discriminate in any way against those who may have applied for an application for pandemic pay, or those who may deliberately disinform or misinform or dissuade an employee from filing an application for payment under the program. Again, this is a program now that the employer is not paying for, but the thought that somehow employers might dissuade people from applying. This takes care of that. Now, this is what we'll call it some of an awkward segue. This law prohibits, as against public policy, contracts between homemaker companion agencies and a client from including no hire clauses that should a client hire an agency employee. And it prohibits those contracts, these no hire provisions, or non-solicitation provisions are often called, for this specific area, homemaker companion agencies. And it also assesses fees, poses a penalty for those who do, and contains basically a claim, that could create a claim for breach of contract assertion. So any type of things you may put in here, basically you can't include these provisions in a contract for those companion ones. Now, here's the thing. This is the awkward transition. The current law already bars covenant non-competes in employment contracts for homemaker, companion, or home health care services, which leads to, drum roll please, some interesting bills that did not pass in 2022. This is one I was kind of shocked didn't pass. This is the non-compete agreement. Again, I put on each of these slides did not pass, so you don't get confused now. Rest of these slides, again, did not pass. Don't worry about them, but they may come up in a future legislative session like next year. There are many states, including some of our neighbor states, that have restrictions on covenants not to compete. And to a large degree, this would have, I would argue, is not too dissimilar to what's in the law currently about, reasonable length of period. But what is interesting, these would have included a bar against these being placed for those who receive a compensation it has to be 3 times or more the minimum wage. So those who make less than that, that goes without saying, you could not have imposed any non-compete agreement. So even, you have to even have a threshold to be eligible to have this law apply. And then if you have it, if you're able to do a non-compete agreement for those who make 3 times the minimum wage, which is, could be significant. Here are the restrictions for those we'll call them medium to high wage earners would have been in place. Again, this did not pass. Something like it might pass in the future. A bill that would have prohibited hospitals from requiring nurses to work overtime. did not pass. That was actually, I think it got through at least one body of the, it may have passed by one house of the legislature. There was a bill that was controversial and it did not pass at the end. I think the Senate may have killed it. That the exception for eligibility for unemployment compensation for striking employees, it would not have applied after the 2 weeks. After a period of 2 weeks of such labor dispute, that means after 2 weeks of striking, you would be eligible. There was a law that would have covered employees of warehouse distribution centers. I think that's a fancy way of saying Amazon, and would require employers to provide to employees a written description of their quotas and the potential adverse employment action that an employee may suffer to failing to meet that quota. I think there were provisions in the law too about allowing bathroom breaks and certain things about not applying against quotas. And an employer could not take adverse action against an employee for a quota that had not been disclosed. There was a lot in that bill, did not pass, but stay tuned because this is an area of high interest. Speaking of an area of high interest, this is largely dealt with what we call, retail and food services, what are called a fair work week schedule. It would have applied to employees with at least 500 employees globally or franchise thereof. In other words, McDonald's. And it would have required employee predictability, scheduling predictability in certain shift changes, allowing people to submit in advance, what their preferred shifts were, notice requirements. It was a pretty hefty amount of stuff. If you want, I can forward you, in my blog, in a blog post I wrote about this for my law firm's employment law blog, I wrote in detail on this. I can forward to you. It was a pretty lengthy bill, would have been pretty onerous. Another bill that did not pass, would have expanded the workers' comp benefit to post-traumatic stress disorder to all employees for witnessing certain traumatic events. In other words, deaths or maimings. Now, this benefit's currently available to certain first responders. This would have made it available to all employees. Did not pass. Comes up every year. This is the paid sick law expansion. It would have expanded the current paid sick law to all private sector employers, as opposed to all employers with at least 50 employees and just service workers. Would have expanded the level of type of leaves you could have done to including, kind of like the FMLA now, state FMLA, to include not just children, but also children, siblings, parents, grandparents, grandchildren, and everyone's favorite clause, anyone related by blood or affinity whose close association is the equivalent of a family member. This is in the state FMLA. Increased the amount of time you could, how to accrue it, which would increase the benefit, and broaden the purposes for the leave. It would have included also a time when an employee needed to take care of a family member whose school or place of business has been closed due to a public health emergency. This is obviously, conditioned upon the days of quarantines, which hopefully we'll never see again. This would have included, the Connecticut Fair Employment Practices Act. It would have made a discriminatory practice to request or require a social security number on an initial employment application. This again did not pass. Would not have applied to certain, if it was a bona fide occupational qualification or if it was required by state or federal law, but you would not be able to, the name, date, you couldn't require a social security number. It did not pass. Another bill about, right now, police officers and firefighters have what we call portal-to-portal workers' compensation coverage. That means basically when they leave the home. This would have expanded it to dispatchers. This bill did not pass. A couple more slides before we get out of here. This bill would have, last year the legislature passed this bill about certain laid off workers and levels of seniority. It provided in certain, basically for certain employees who were laid off at a certain period of time from March 10th of 2020, which was the magical date our lives all changed due to the pandemic, and May 1st of 2022, would have basically, that right now there's certain benefits provided in terms of recall rights for certain employees in the hotel and lodging and food service industry. For basically imposes a seniority requirement for layoff rights, which looks like a collective bargaining agreement pretty much, but it imposed it in these industries. This would have extended the provision for another year for those employed after to those who had a layoff occurring up to May 1st of 2023. And it would have extended who was eligible to cover those diagnosed with COVID up to May 1st of 2022. It would have added, basically would have added another year for those who were eligible by layoff and those who were diagnosed with COVID. This bill did not pass this year. I assume it won't pass next year as we get farther away from the pandemic. This is about, we'll call it forced arbitration agreements, and would have created a method for whistleblowers or the organization to initiate what are called public enforcement actions in the Superior Court, basically to enforce public, employee protections regarding employment regulations. Even if you were, quote unquote, you would not be, these things could not be impaired by any private agreement, such as a quote unquote forced arbitration. This was the forced arbitration bill, allowing people to bring actions in the courts. It did not pass. It's come up a few times in the last few years. It may, stay tuned. This would have allowed one bill that would have allowed probate court judges to, probate court employees, not judges, sorry, probate court employees to be considered state employees for purposes of collective bargaining, to unionize them. This has come up the last 2 or 3 years. This did not pass. And this bill would have been very specific, another bill about pension and retirement system from diminishing or eliminating any right to benefits due to receipt of permanent partial workers' compensation benefits. And it would have prohibited a municipality from diminishing a pension benefit due to receipt of these benefits, or it will not have interfered with collective bargaining provisions that were previously negotiated. Again, this bill did not pass. This bill, another bill coming toward the end here, like this might be my last slide. Actually, guess what? Little coming attractions here. It would have clarified the definition of employer under OSHA to cover volunteer fire departments and ambulance companies, to the extent they're regulated by the Federal Occupational Safety and Health Act. It would have been regulated by the state one. And it would have said now, for first violation that were not serious, volunteer fire departments would only be issued a written warning. So this bill did not pass this year. It came up last year, may come up again. The most important slide, a picture of me from December 2013 when I was younger. My contact information, you'll get this off. Now, this is the point of time where I'm going to say, are there any questions? Now you get to see me.
Haven't gotten any questions yet, Mark. I've got to say I'm always impressed with the breadth of laws that you cover in this presentation. It's got to be a full-time job just keeping track of all of them.
It's for purpose of full disclosure, I am the longtime legislative liaison of the Connecticut Bar Association's Labor and Employment Law Committee. I guess I feel like almost like I'm Fidel Castro with that role. Maybe at some point I'll get out of the role. But so I cover it for our blog. But yeah, and again, this was a quiet year, but that's why I put in the laws that did not pass, because next year will be a less than quiet year. I'm not a political prognosticator. I have no idea what the legislature will look like next year. Obviously, if there's a certain composition, or even if there's a change in the governor's office, maybe some of these bills may not occur. Maybe others will occur, but I want to at least put them all out there for people to see, know, and understand them. And it may affect you in advising the people you work with.
Yeah, and I always appreciate the fact that you reference those sneaky bills, the bills that get snuck into the implementer bill, because people don't pay attention to that. They think it's just the budget bill, and it's not.
Yeah, I'll give you one I didn't even put in here because it was kind of iffy. But in the area for school districts, there was a child mental health bill, Public Act, I think it's 2280, where in that bill was put in a provision. There were a lot of things that had nothing to do with mental health, but there was a provision put in there about guaranteeing teachers a 30-minute uninterrupted duty-free lunch. That's again, I see people that may have different views on that. I'm not going to comment on my own views on it, but that was something that was put into that bill as a last minute amendment, that if you weren't following the bills, even if you're following the bills, they were not necessarily in the bills, but then they were put, it was then, because it wasn't even a separate bill. There are times things get in implementers that were not even, there's times you put in an implementer bills that had been discussed during a legislative session that didn't make it out of committee, or you do something like that. But there's other times things get in the bill that were never ever discussed or given a committee hearing. And that's always this frustrating, because at least you should at least have a learned discussion on these matters. But that's just me pontificating. So,
Right. Well, no, I agree. I mean, the purpose is to have people be able to participate in democracy, right?
yeah, I mean, I'll tell you, I once had a situation where I saw both sides of it. One year, I had an implementer come in that hurt my clients at the last minute. It took away a victory I won at some hearing, and people said, "Oh, they didn't know they were voting for it because they just voted for the whole thing." And then 6 months later, the next implementer got rid of that, and people voted against it who would have voted for it but didn't know it was in there. So it's gone both ways for me. I'll be honest. I've benefited. My clients have benefited. My clients have been hurt by it. But again, legislative process 101. I always quote what now Judge Rohrabaugh said when he was a senator. It was 11:45 at night, and he said, "This may be the greatest bill of all time, but I have a rule: if I've not read the bill first, I can't vote for it. It'd be nice if you at least read the legislative summary prepared by the Office of Legislative Analysis before you vote on a bill. At least read 200 pages before, if not the 700 pages before you vote for it."
Yeah. Well,
These questions coming in now. Come on, people.
Yeah, I don't see any questions. I see lots of kudos to you for your wonderful presentation. So yes, we will be sharing the slides with you. And yes, if your name is visible on the Zoom, we will be sending you a CLE certificate for your time today. And Mark, thank you once again for doing this presentation for our membership.
Thank you.
I really, really appreciate it. Thanks to all of you for attending and approving our bylaws. And please go on the website and register for our program, our in-person program in October. It should be fantastic. And we'll see you then. Thank you so much, everyone.
Bye-bye.
Bye, everyone.
Bye.